Those are the 3,300 ballots in Palm Beach that we have contested, where a decision was made not to count them in the manual recount, but we have contested that decision. The 9,000 ballots in Miami-Dade that have never been counted, and the 388 ballots in Miami-Dade that have been counted. We agree with those counts, but it may be that the defendants disagree, and that will require the court to review them. Now let me touch on a couple of arguments that I know that the defendants are going to make because they've made them to the court before. And obviously I will respond in rebuttal, but I want to have the court have a context of what our view is when the court listens to what they have to say. First, there may be an argument, they've certainly made this argument before, that somehow you have to recount all of the ballots if you're going to have a contest on any of the ballots. That is something that I challenge them to cite the case that says that, because the statute doesn't say it, and the case authority in which circuit courts and the Florida Supreme Court have repeatedly had election contests in which they have reviewed less than all of the ballots at issue are to the contrary. Because what the section says is that you have to look and you have to test the allegations in the complaint. And the allegations in the complaint are the ballot contests that we've identified. Now, second thing that they've begun to say, and that they may argue today, is that somehow the Miami-Dade ballots have been contaminated in some way. Now, exactly how that has happened isn't particularly clear. Nobody has brought in any evidence. There was a suggestion to the court that they needed a witness to identify the ballots. Florida law makes clear that the ballots themselves are official records. You don't need a witness to testify to the ballots. I think that however creative their argument is in terms of contamination, that is clearly something that they bear the burden on, and that burden has not been met. Indeed, if you listened to the people from Palm Beach County and you listened even to the Republican observers from Miami-Dade, I think the court got the sense of citizen officials trying their best to deal with a difficult situation, making every effort to get it right, keeping close controls. The court is well aware from telephone conversations and from this hearing of Mr. Greenberg's intent to make sure that Miami-Dade got it right, and that when they moved the ballots, they moved them in a way that this court directed, so that there would not be a chain of custody type argument that tried to distract the court. So the court has the ballots have been segregated, that is the undisputed evidence, and those ballots are available for the court to review. Finally, they have argued from time to time that in this case, in this contest case, that other matters should be injected, matters from other counties with which they may or may not have a disagreement. You've heard the interveners argue that somehow the court should take into account in this contest whether or not the networks prematurely called the race for Vice President Gore to the detriment of Governor Bush. I think the court has no competent evidence before it from which the court could conclude that that had any effect on the election. But irrespective of that, and more important than that, whatever effect that had, is not relevant to a contest action, which under the terms of the statute simply asks whether there have been legal votes rejected or whether there have been illegal votes received. And it is up to the plaintiff to identify the legal votes that the plaintiff claims have been rejected and the illegal votes that the plaintiff claims have been received. And we've done that. We've done that in each of the 5 issues that we've put in front of the court. Those, we respectfully submit, are the issues for the court to decide. Some of them issues of law, others the issue of the application of law to the individual ballots themselves. Thank you very much.
Thank you, Mr. Boyce. Richard?
Please the court. Like Mr. Boyes, I return to my opening statement and the threshold question that I believe defines the task that this court faces in this proceeding. And I believe that a good beginning point to analyze that task is the statement of the Florida Supreme Court in the 1981 case of McPherson versus Flynn at 397 Southern 2nd, 665, in which the court said, since there is no common law right to contest elections, any statutory grant must necessarily be construed to grant only such rights as are explicitly set out. In other words, among the 3 co-equal branches of our government, it is the legislature to which our Constitution has entrusted the right and the responsibility of determining the circumstances under which an election can be contested, and there is none other than what it has stated. So too, the Constitution has entrusted the legislature the right to determine when, if ever, there shall be a manual recount. And I pause here to note that there is no right by the federal or the state constitution to manual counts ever. Now, the Florida legislature has indeed told us in very explicit terms the circumstances under which there can be a manual recount and what body makes that decision. It did it in section 102.166, subsection 4C, a section which Mr. Boyes conveniently ignores. And here's what it says. The county canvassing board may authorize a manual recount, period. Now, the county canvassing boards are interesting bodies. They are unique within our system of government. The legislature has provided that they shall be composed of a representative of each of the branches of government. A judge, a supervisor of elections from the executive branch, and a member of the county commission, indeed the chairman of the county commission, a legislative branch. All of them, with the singular exception of Dade County, elected officials, and all of them at the closest level of government to the people. And it is that board, and that board alone, to which the Florida legislature has entrusted the decision as to manual recounts, and I defy Mr. Boyes to find for this court any other provision of Florida law that entrusts that decision to any other body. Now, in his effort to suggest to this court that the review of ballots is de novo, he rests upon a premise which I suggest his entire case needs for success, and it is this: that there is something different about a Section 168 contest than the provisions of Section 166, which lay out the circumstances for recount. Mr. Boyes suggests that once a contest has been demanded under Section 168, that we no longer concern ourselves with the authority of the county canvassing boards. They essentially disappear. And what they have done is no longer important. It is no longer a question of abuse of discretion. Just 2 weeks ago, the Florida Supreme Court in Palm Beach County Canvassing Board versus Harris told us this: the decision whether to conduct a manual recount is vested in the sound discretion of the board, and they refer to the county canvassing board. Once the county canvassing board has made that decision, there is only one other provision in Florida law for a person to challenge it.